So, picture this. You've proven someone was negligent. They had a duty, they breached it, and you suffered because of it. Case closed, right? It seems like a slam dunk. But you know, in the world of law, it's rarely that simple. Because even a defendant who's clearly been negligent has a couple of last-ditch arguments, a couple of shields they can raise to protect themselves. Let's dive into how they work.
And that's really the heart of it, isn't it? Just because you've proven your case doesn't mean the story's over. The defendant gets their turn, and their arguments can totally flip the script, either wiping out their liability completely or, at the very least, taking a big chunk out of the final bill.
So this is where we get to the defendant's final play. These things called legal defenses. It's a fascinating moment in a case because the tables actually turn. Now it's on the defendant to prove that, yeah, they might have been negligent, but there's a really good reason they shouldn't have to pay for all or maybe even any of the damage. Okay, let's think of it like this. The defendant basically has two types of shields they can choose from. First, you've got the all-or-nothing shield. This one's a huge gamble, a real high-stakes move. If it works, the claimant walks away with absolutely zero. Then there's the damage reducer shield. This one is way more common, and just like the name says, it doesn't block the whole attack, but it can seriously shrink the size of the final payout.
So, let's start with that high-risk, high-reward shield. This is the one a defendant pulls out when they want to argue that the claimant knew exactly what they were getting themselves into and, with their eyes wide open, said, yeah, I'll take that risk. And this shield has a pretty fancy Latin name, Valenti non fit injuria. All it really means is, to a willing person, no injury is done. And it's incredibly powerful. If a defendant can actually prove that the claimant willingly consented to the specific risk of being injured, it's a total knockout blow. The entire claim is defeated. Done.
But here's the thing. The bar for this defense is incredibly high. The defendant has to clear all three of these hurdles. It's not enough to just show the claimant knew there was some risk. They have to prove the claimant knew the specific nature of that risk and, this is the big one, that they made a genuine, free choice to accept it anyway. And honestly, that last step is where this defense usually falls apart.
All right, let's switch gears and talk about that second shield, the damage reducer. You see this one pop up in court way more often because it's not about accepting the whole risk, it's about sharing the blame. And the legal term for this is contributory negligence.
So with this one, the court is asking a totally different question. They're asking, hey, did the claimant fail to take reasonable care for their own safety? The law isn't saying the accident was all their fault. It's saying their own carelessness made the situation worse than it needed to be. And if the court agrees, they'll just knock down the compensation by a percentage that feels fair. This next case is a brilliant and maybe a little funny example of how this all works in practice. It's a famous one, Sayers v. Harlow. So a woman gets trapped inside a public toilet cubicle because the lock is broken. Now, the local council was clearly negligent for that, but to get out, she decides to try and climb over the door, using the toilet roll holder as a foothold. And, well, you can probably guess what happened next.
Of course, the toilet roll holder broke, she fell, and she got injured. The court said, yes, the council was absolutely at fault for the broken lock, but her method of escape was, let's just say, a bit careless. So they decided to cut her damages by 25% to reflect her share of the blame for how she got hurt.
The big takeaway here is simple, but it's really powerful. Even when somebody else's mistake puts you in a tight spot, you still have a responsibility to act reasonably to keep yourself safe. You know, her panic was understandable, but the way she chose to act contributed to her own injuries.
Okay, so we've got our two shields, the all-or-nothing Valenti and the damage-reducing contributory negligence. Now for the fun part. Let's put them to the test in a few very different real-world scenarios and see how they hold up.
This next case is just wild. Imagine this. Two friends spend all afternoon drinking a ton of whiskey. One of them happens to be a pilot, and he suggests, hey, let's go for a spin in my light aircraft. The other friend not only agrees, but actually helps him get the plane ready for takeoff. And up they go. As you might expect, the plane crashes. The pilot is killed, and the passenger is very seriously injured. And here's the absolute shocker of an outcome. The court said the all-or-nothing shield worked. They decided that the act of getting into a tiny plane with a pilot who was that drunk was so, and I quote, blatantly and obviously dangerous that the passenger had, for all intents and purposes, willingly accepted the risk of exactly what happened. He got zero compensation. Nothing.
But, and this is a huge but, the law specifically bans that exact offense when we're talking about drunk drivers in cars. Thanks to the Road Traffic Act, a drunk driver cannot argue that their passenger consented to the risk.
In that situation, a court would immediately grab the other shield, the damage reducer, and would probably reduce the passenger's payout for getting in the car, but they would never wipe it out completely.
So, what about at work? How do these shields play out there? Well, in an employment setting, that all-or-nothing shield is almost useless for an employer. There's this classic old case Smith v. Baker that explains why. A worker was injured by a stone that fell from a crane. He knew the crane was operating above him, and his employer argued that since he kept working, he consented to the risk.
But the court said, no way. And the reason is simple: economic pressure. An employee who complains about a dangerous practice could get fired. That's not a real choice, is it? So the courts have basically said, knowing about a risk at work is not the same thing as consenting to your employer being negligent. The only time this defense really works is in a rare situation where employees team up to deliberately break the safety rules together, like in that Shatwell case.
The damage reducer shield, though, that gets used all the time. And there's no better example than seatbelts. This landmark case, From v. Butcher, set up a really clear formula that courts still follow. If not wearing your seatbelt is the sole reason you were injured, your damages get cut by 25%. If it just made your injuries worse than they would have been, it's a 15% cut. And if wearing one would have made no difference at all, well, then there's no reduction. Simple as that.
So, we've seen these two very different shields in action. To wrap things up, let's just put them side by side for one final crystal clear comparison. This table really sums it all up, doesn't it? The all-or-nothing shield is a total defense. It's subjective. It's all about what that specific claimant knew and willingly accepted. And because of that, the burden of proof is super high. It's really hard to win with. On the other hand, the damage reducer shield is only a partial defense. It's objective. It just asks what a reasonable person would have done for their own safety. It's focused on carelessness, not consent. And that's why it's far, far more common in court.
When you boil it all down, it comes to this fascinating legal line. The line between freely accepting a huge, obvious risk and simply being a bit careless about your own safety. The law has drawn its own lines, as we've seen, in some pretty interesting places. But it does make you think, in these messy, real-world situations, where would you draw that line?